Welcome back to another edition of Between Two FARS. I'm Warneke Miller, and I am joined by Judge Reid Prouty from the ASBCA. He is Vice Chairman, and he's been with the ASBCA about 7 years now. Prior to that, he did 15 years with the Department of Justice in their contract litigation unit, and also 7 years as an active duty Air Force. It's just amazing that you've been through all of that and are willing to come and talk to us. So we really appreciate your time today and would like your insight on how the ASBCA runs. You know, we're attorneys, we go there, we give it our all, we throw you our closing briefs, and then we wait. And there's this period of time where we're not really sure what's going on inside the black box of the ASBCA. Could you just talk us through the decision-making process? What goes on to render a decision?
Sure. As you know, the ASBCA is a board, and for every decision that is dispositive, unless it's a Rule 12, and those are the very few cases where it's a very small dollar figure and the parties have opted to go for that expedited decision making, you have 3 judges on the decision. And the way it works is the judge who heard the case, unless she or he retired or something, typically drafts the opinion saying, here's what we're going to rule. And they submit that to a vice chairman like myself, who review it, and we make sure that, yeah, we agree with what they say, or maybe we should change this or that, or maybe add this or that. And then once that's agreed to, we bring it to an acting chairman, and he, in this case it's a he, takes a look at it and does the same thing. Once we're all 3 on board with the decision and the results, we put it in the right format and it goes out. Now, the concurrence process doesn't take super long, but it does cause us to be pretty careful. And you might ask, why do you go through all this process? Why don't you just sign off on it? There's a lot of reasons for that. One is we want to get the right answer, of course. The second thing is that it's not just a question of the right answer, but saying it the right way, because our decisions are precedential. To us, that is. And you might think, well, okay, it's precedential, that's important. It's actually very important for a lot of reasons. One is that DoD and NASA contracts, which is what we cover, are the vast majority of government contracts that have disputes about. So there's a significant responsibility system-wide. Also, if there's just a few careless slips of the pen, perhaps you paraphrase something and you leave something out that doesn't matter for this case, but might matter for another case down the road, you've got yourself some bad precedent you're obliged to follow. So as a consequence, we are very careful. Some might say that the vice chairmans are uptight about it. To get it right and not to accidentally say something that gets us in the wrong. So that, in a nutshell, is the concurrence process. Now, by the way, there are occasions when we might disagree with the drafting judge. And if that's the case, that's okay. We're all equal as far as our votes go, so the vice chairs don't get to overrule that judge. We might get to the same result with a little different language, and we disagree about the law, we still get to the same place, in which case we concur in result. And when you have a concurrence in result, you still only need 3 judges, but the decision is not precedential. And the concurrence in result itself is not precedential either. There's just basically no precedent that issues from that decision. The alternative is that sometimes you look at it and you come to a completely different conclusion about who should win. We don't do this lightly, but sometimes it happens, in which case you bring 2 more judges in, so there's 5 judges who consider it, and then you sort of vote on it, and so you can get majority and dissenting opinions. In the case of a 5-judge decision, the majority opinion is precedential, but of course that takes more time. Again, that happens maybe once or twice a year at the most, but it does happen, and it's fine. If somebody legitimately holds an opinion that's different than some other judges, which is known to happen, the board deals with it.
The concurrence in result that's non-precedential. I'm looking at something on the ASBCA website. How can I tell whether or not this opinion is precedential or simply a concurrence in result that is non-precedential?
Sure. You flip to the back where the signatures are, and you'll see basically, such and such. You'll see the signature of the judge who wrote the opinion in the first instance, and then you'll see the next 2 signatures will say concur in result. And sometimes the concurrence in result will actually have a short explanation of why we got there. But it'll say concurrence and result at the very end of the decision, and you'll see. So there'll be no mystery to it.
Excellent. Now that is very good news we can use. Some other thoughts that go through the litigation attorney's mind. We are throwing a ton of documents at you between the Rule 4 file and our pre-hearing briefs and our motions for summary judgment and sometimes post-hearing briefs. What's most important? What are the judges looking at when they're refreshing their recollection about the hearing, about the case, and sitting down to write their decision?
The most important, and I guess if there's going to be a takeaway from my day and a half here talking to you, it is the most important document is your post-hearing brief, bar none. Okay, and that's because when the judge sits down to write it, the post-hearing brief will have included all of the testimony at the hearing. It'll have included all the documents in the Rule 4. It will use the ones that the writers think are important. It'll sort of distill what the case should be about. And so, for example, when I'm reading a opinion by another judge to concur with it, what am I going to do to educate myself about the arguments that are made and things like that? Well, it'll be the post-hearing briefs. It's very unlikely that the pre-hearing briefs, as important as they are to sort of set the stage for the hearing, and I don't diminish their importance at all for getting yourself ready for the hearing, but as far as writing the decision, it's the post-hearing briefs, and their replies that go along with it that are what the judges are going to be reading. So that's your time to shine, and where you can be effective in a post-hearing brief. I'm going to anticipate your next question. is show me in the record, whether the record be the Rule 4 file or the hearing transcript, where the facts that lead to your winning, the conclusions you want us to draw, may be found in the record. As you know, Rule 4 files can get quite extensive nowadays, and there's no way on God's green earth a judge is going to read every document in the Rule 4 file. It's just physically not possible. And so we count on you to find where in the record it supports your contentions. Now, on occasion, people in their post-hearing briefs make statements without supporting, they don't cite something to it, and that is worse than useless. The judge is going to say, well, they say this, but there's no evidence for it, and that doesn't make you look good. So if you're going to say something, you got to have a citation to the record or the hearing documents to support it, or the transcript rather. Then I'll add the follow-up question after that is how important is the law part of your brief?
Yes.
It's important. It's important that you make arguments. That is, if there's an argument that's not made in the post-hearing brief, it's often considered waived. So if you think, hey, this is a differing site condition, but it doesn't meet this element of it, say that. Don't count on us to sort of say, oh, I don't see the third element of the differing site condition. If you didn't say it, it's very unlikely that we'll look for it, and it's very likely that it could be considered waived, because of course the other side won't have the opportunity to respond to that. And as far as having the best case law in there, definitely cite the appropriate law. Definitely make sure you're educated on it. But the truth is, the great advantage of contract law is that it is a finite source of law. It's broad and it's interesting. But we are a specialized court, so a type 1 differing site condition, we've seen that before. How you interpret a contract, when it's ambiguous, well, or the tools you use, we've seen that before. It doesn't mean you should ignore that. It doesn't mean you should not cite any law for it. You should, but understand that, just as I said earlier in this discussion, we don't want to make bad law. Just because somebody like you or the other side may have quoted a case that was overruled 20 years ago, hopefully we're smart enough on the law on that to say, yeah, we know that used to be the case, but that's not the case anymore. And we'll catch that, because we certainly don't make the obvious mistakes, which doesn't mean that if your opposing counsel makes a mistake, you shouldn't point it out in a nice way. And it doesn't mean that you're absolved of all responsibilities, because don't worry, the judges will catch it. But you do have a sort of a backup that, hopefully we know this stuff, and we'll know it sort of sounds right. It's like, yeah, that's consistent with our knowledge of the law, and that's again part of the reason why you have 3 judges reviewing it, because between the 3 of us, hopefully, we're not going to let a simple mistake get past us. as I'm knocking on wood here.
Knocking on my formica here.
Exactly.
Do you ever find a case where either side is bringing up some case law and you think, oh, that's interesting, that's novel, that's different, let me dig into the case law? Do you ever have to do any independent research yourself to issue a decision?
All the time.
Really?
All the time. I mean, I say all the time, certainly not all my cases,
Right.
maybe not even half, but just by virtue of the number of cases, it's pretty common that, yeah, we'll sort of crack the books a little bit. I say, let's do this. And there always are issues of first impression. Not very often, but they're always going to be there. So, yeah, we do all of our own legal research. One thing you should know is that we don't have clerks. We have staff attorneys who assist on many things, but for the most part, the person drafting the opinion is going to be the judge who heard the case. And what that means is she or he is figuratively and literally going to have the Rule 4 file in their lap in the computer as they're typing up what the evidence was and things like that. So that adds a little bit to the time. One of the great things about it, though, is that when you do that, you have an understanding of the case far greater than you would if you just sort of delegate it to a clerk and say, draft this up, this is the result I want. It kind of helps to actually have to live in the weeds, which we do, which is part of the reason why
You're
we don't issue this
on this stuff. I mean, you're actually living in it and dealing with it every day.
Sure, but it also means that's why it doesn't take 2 weeks. It takes a little bit longer to get a decision out because we want to get it done right. And remember, it's got us. Not only does we have to produce precedent for us to follow, but it has to be also withstand judicial review. And the Federal Circuit gives us a lot of breaks as far as substantial evidence test. And part of that's because they trust us, because we are going to make sure internally that if we're citing a fact, there's support for it in the record.
Terrific. We really appreciate this insight into the workings of the ASBCA. And we still have more to discuss with Judge Prouty, so don't go away and join us again next time on Between Two FARS.